Chillie DeCastro's Las Vegas Police Department lawsuit. I want to give you a quick update on it. I read the docket. It's in federal court. He's asserting all kinds of civil rights violations. His legal work is getting better, but it's a work in process for anybody. I don't care who the person is. When I graduated law school, I didn't have the kind of skill I have now, obviously, to draft a complaint and get the wisdom from it. So I don't know if someone's helping him behind the scenes. The writing is getting better, but there's still lots of problems. You run into a lot of trouble when you try to take on all these parties all at once because they just team up on you. Uh, he's filed a complaint, then he filed a first amended complaint. Now he's on a second amended complaint. The second amended complaint was in response to a motion to dismiss. In federal court, you have what's called Rule 12b-6, which is a motion that says, hey, even if we take everything you say is true, you don't set a claim here that can give you any kind of relief because it's all based on facts. Okay, just some quick ones here. He tried to file a motion to recuse the judge. That was denied. It was Ninth Circuit, sorry. And the preliminary injunction motion that he brought failed on its face. I mean, normally these kinds of motions go for in federal court, I think there's a 35-page limit on a memorandum, it's 15 pages in state court, but it's got to be really well argued, lots of evidentiary facts, declarations. You have to set out the four factors, whether or not the court could even entertain it and grant it. One of them is whether or not you would succeed on the merits. And if you mess around with that, it's just going to be denied. He filed the lightest one I've ever seen. I mean, it was 4 pages, which is never going to get it done. And a judge is not going to also the point of this preliminary injunction was to block the state court trial from going forward. Federal courts do not have unlimited jurisdiction. They're courts of limited jurisdiction. They only hear certain types of cases. He tried to get the judge that he tried to recuse, Judge Gordon, to reconsider his preliminary injunction. And this was, he does not offer sufficient reasons for me to change my mind. That's pretty hilarious. Sometimes they're even more blunt, denied without even a reason. The judge made a ruling. I want to show you the ruling here. So this is the ruling in response to a Rule 12b-6 motion to dismiss by all the defendants. And the judge granted in part, denied in part, and I'll just skip to the back end of it. It says here, these claims, when they're dismissed with prejudice, means you can't bring them back. But that's not always true. Remember, we're at the pleading stage right now where the facts are presumed true so that the judge can see if you've set forth a cause. So the Fourth Amendment, unreasonable search and seizure, gone. False imprisonment, gone. Invasion of privacy, gone. Negligence based on an arrest and the search, not gone. And when it says without prejudice and with leave to amend, the judge is saying, okay, I'll allow you to plead it again, but they do not usually give you more than a couple of chances. These are some of the way these things are styled are not the way you normally style claims anyway. That is a serious strike against him because it makes the complaint kind of hard to work with, and it kind of tells a long story when it really doesn't need to. The 1983 claims, well, he tried to bring in the Las Vegas Police Department, but there's no entity liability for a 1983 civil rights violation. Negligence based on biased policing, the judge is saying, I'll let you plead that claim. It's been scaled down only if you can show me that normally they would not arrest you in this situation. Yet, even taking the amended complaints allegations as true, which is what happens under a Rule 12 motion, just like it does in state court under demur, the officers had probable cause to arrest DeCastro for obstruction. Nevada law makes it a misdemeanor for any person after due notice, and there it is, hey, don't do this. I'm a cop, I'm telling you not to willfully hinder, delay, or obstruct any public officer in the discharge of official powers or duties. And it cites the same code section that he is being charged with in the state court. So there you go. You got a federal judge saying that, you know what? I think you're going down for this one. At least looking at this, I think that you are guilty. These, again, do not belong in a pleading. It just makes you look bad. Profiling against members of the press. Profiling against the press, you're not going to get a lot of sympathy for that one. And it's not a protected right. The press is not a protected class. Doesn't belong in the complaint. This one was, there was the Roman emperor. He was a famous guy. He walked around really brave. His name was Testicles. Do you remember that guy? Sandoval said that plaintiff needed to be patted down again. Plaintiff protested that he'd already been patted down by 2 officers. Sandoval then spread plaintiff's legs uncomfortably wide and purposefully and maliciously and with significant force struck plaintiff in the testicles with what felt like a closed fist. Plaintiff yelled in pain, "I can't believe you just hit me in the nuts." Yeah, there it is. You don't have to really quote yourself in that. Okay. Plaintiff was forcibly placed into a police vehicle by defendants who pulled the seatbelt as tight as they could. They, okay, who's they? And defendants, well, you've listed 6 people, I think. All 6 of them put you in the police car? All 6 of them fastened you down? Probably not. Very bad pleading. Therefore, your imprecision will bring another motion to strike or a motion to say that your facts are not pled correctly, because each defendant has a right to know what they're being charged with. And when you write sloppy shit like this and you just smear it on everyone, one guy says, "Wait a minute, I was never involved in any of that," and he'll attack your pleading. So you gotta be careful how you draft pleadings. Counter, he had no criminal record. Well, I don't know why you needed to include that. I thought I saw some websites. One of them was the Welsh Network. Cool website that they did find some convictions. I haven't checked that, but they said here, plaintiff's negative viewpoint of police who all contribute or hold silent, the thin blue line. This is all speech writing. Doesn't belong in a complaint. The color of plaintiff's skin, I don't think that had anything to do with him being arrested. I think it was his camera. Then he says, arrest without probable cause. Well, listen, this is a brand new one. These are my notes right here to myself. A new cops had probable cause to arrest him. So when he says arrest without probable cause, it's going to be stricken right away, that claim. The factual allegations show, again, he's saying exactly the opposite of what a court order already said. So you can't go there, and you did it anyway. Excessive force in the use of an arrest. I think that part was allowed to go through. Oh, this one's going to be a real killer for him, I think. He brought in now a new claim under California's anti-SLAPP under section 425.16. The sections E1 through E4, E4 being the catch-all. But it's different in Nevada, but they're all part of the Ninth Circuit. I'm sure Nevada's got its own anti-SLAPP law. You have to be so careful when you start alleging that people violated your civil rights, and then in so doing, they're saying, wait a minute, I exercised my civil rights, my protected rights to do what I did, and you're suing me for that. Bam, in comes the anti-SLAPP. Anti-SLAPP can put you in hell. First of all, if they beat you on the anti-SLAPP, you owe their legal fees, and I have a feeling that's going to be quite a lot. Secondly, if they lose the anti-SLAPP motion, they get a free appeal and an appeal again to the Supreme Court. If they win eventually on appeal, you get to pay all those legal fees too. If you beat them, you don't get legal fees. Only they get legal fees. So what happens if you beat them and then it gets overturned at the Supreme Court level, and now attorney's fees are $100,000+, and we've got several defendants. They may all be filing their own anti-SLAPP motions, and now the fees grow really fast. This will be a problem. So with that, right now, I think he'll be facing a lot more motions, and then I'll update you when that happens. But so really nice. I got a letter that